Hello there, folks. This is your friendly, experienced lawyer here with video number 3 on our videos on whether you ought to go to law school or not. Today we're going to talk about some of the things about law practice. Practice of law is very interesting. Probably there's no question in my mind that in a lot of respects there's nothing that I wouldn't rather do. I like dealing with the subject matter, but for the business aspects of it and the regulatory aspects of it, it's almost like it takes the entire joy and profitability out of the enterprise. There are exceptions to every rule, but unfortunately, sometimes the exceptions become fewer and far between, and they never seem to work out in your favor. Let's talk about some of the things. The legal profession is very heavily regulated, and it's these regulations where you don't run it like a regular business. Let's just talk about a few things. As a lawyer, you have a fiduciary duty to your client. In other words, you've got to look out for their best interests. Now, I don't care whether they're supposed to look out for your best interests or not, but clients do not look out for your best interests. I basically have a rule of thumb as a lawyer. If a client tells me something, I think that there's a 60% chance that what I'm being told is either they're confused, they're omitting something, or they're just outright lying to me. The other 40% of the time, I'm probably getting a straight story. Now, sometimes, a lot of times for that misinformation, it's just because the client doesn't have the educational background. Their memory is a little faulty. My memory is not always the best. And it's for innocent reasons, but sometimes they just tell you fibs, okay? And they tell you what, I don't know what it is, but sometimes they think that you're gonna have a bad opinion of them or something, but they just don't give you the straight story. And this all has a big effect because you structure your fee arrangements with the client, what you're gonna charge them based on a certain set of facts. And if those facts are wrong, guess what? Your fee arrangement's all messed up. This is particularly true in a contingent fee case, like a personal injury case, where you only get paid if you win. Well, if your client is lying to you, or fibbing to you, or has bad recollection, guess what? You're going to spend maybe a year or two on a case, spend $10,000 on expert witness fees, and guess what? You don't win, you don't get paid, and that comes out all out of your pocket as the lawyer. And it will set you back and cause you many sleepless nights, if not also a divorce. So we just went over contingent fee cases if you're a plaintiff's personal injury lawyer. You're not allowed to split fee. In other words, marketing is a big issue with lawyers, and the bar would always regulate how you could market. For example, and this has changed some, but we always, if you sent a letter to somebody telling them you wanted to be their lawyer, a lot of times you were supposed to put on the outside of the envelope and on the inside of the envelope in big letters, advertising material. Well, you know, it just looks really tacky. It's like you're setting yourself up to have your mail, the client's going to throw that in the junk mail and stuff like that. They backed off a little bit on that kind of stuff, but you got to understand, back up until like the 1970s, lawyers weren't allowed to advertise at all. And so the lawyers, the old traditional guys not much older than me, have always thought that it was less than professional to advertise. Lawyers are getting away from that attitude by necessity because so many lawyers are out there starving, that advertising sometimes gets to be a little more aggressive, but there's heavy regulations on advertising. You know, I talked about expert witness costs if you're carrying a personal injury case, because you're not getting paid by the client. You've told them that you're only gonna get your money if you win the case. And meanwhile, you're paying for your secretary, you're paying for your supplies, you're paying your malpractice policy, all your business expenses. And this can go on for many months. If it's a big personal injury case, it can easily go on anywhere between one to 3 years sometimes. And your expert in a medical malpractice case, it's not unheard of to have expert witness costs up over $50,000. And guess what? You've got to fork all that out of your own pocket. And this is one reason why those big personal injury case, medical malpractice cases, products liability cases on the plaintiff's end, which are big profit items, but they are big losers, high risk ventures if something goes wrong or your client's not telling you the correct story. So you've got to be well capitalized to handle a lot of the big, better cases. Contrast that with representing more typical things like real estate, residential real estate, home real estate transactions, a simple will. You're talking fees of less than $1,000, and you got to do a ton of those to make any money. And part of your fees, what you can charge, are very, very limited, because you'll have escrow companies, title insurance companies that do closings and things like that, actually competing for a lot of that closing type of business. Wills are generally not a big legal fee item unless you're going to do a big estate tax planning, but there again, you have to have big clients, and normally if you're going to rub elbows and get big estate planning clients, you better probably belong to the right country club, etc., etc. I mean, there is this very, very, I can't emphasize this point enough, there very, very definitely is two realms of existence when you're talking about law. Well, maybe even three. You're talking about people who represent people who are just poor, and then you're talking about people, your average Joe, John Q. citizen on the street, probably making less than the family's probably making less than $50,000. That's the second level. And then there are, the people that maybe six-figure incomes, and representing those people. Because for the first two, for the poor and for John Q. citizen, they can't really afford much in the way of attorney's fees. And the only way, especially for the John Q. citizen client, the only way you make money with those people is you've got to hire a paralegal and crank out a lot of those types of cases or problems or transactions. Not allowed to split fees with non-lawyers. In other words, you can't pay somebody, a non-lawyer, to refer you business. Let me repeat that. You cannot pay a non-lawyer to refer you any business. In other words, you cannot hire a salesman and pay him a part of your fee from your client to go out and get cases for you. Okay, so you have these limitations on advertising. Another biggie, very biggie. This is a complicated subject, but it's a royal pain in the rear end. If you're handling other people's money, particularly like mortgage loan proceeds in a real estate closing, that money has to be put in an escrow, and you have to have a bookkeeping department, very strict bookkeeping and rules about handling those funds. But you also, if you collect if you're lucky enough to get a client that can pay you legal fees in advance, okay? And a lot of clients, John Q. citizen, most of them, you try to get your funds up front, because since they're living paycheck to paycheck, if you don't get your funds up front, you may not get paid. This is particularly true like in criminal cases. But if you collect those fees up front, you can only account for them, and by and large, you can only draw down those monies when they are earned. Well, this sounds very simple, but when you reduce this to trying to actually put it into practice, it consumes a lot of time, effort, and energy from a bookkeeping, a banking, a bookkeeping, time, effort, and energy complying with those rules for people that aren't paying big fees to begin with. The rules ought to be changed in that respect, but lawyers, you can't just all of a sudden, you collect the money up front. Well, guess what? You can't pocket that money. And if the electric company is getting ready to cut off your electricity or your phone service, and if that case is 3 months down the road and it's sitting in your escrow account, guess what? You cannot touch that money in the escrow account to pay your electrical bill or your phone bill. You've got to wait till the end of the case. That's a complicated subject, but as a general rule, that's the kind of difficult, strange situation. Well, you said, well, let's go to the bank and borrow some money. I mean, well, you may get the loan, you may not, but I'm just telling you, it's a big pain in the rear end, and a lot of lawyers get into trouble, and some lose their license over mishandling funds in escrow accounts. The escrow account is like a landmine, a ticking time bomb, always ready to go off. So anyway, so those are some of the things that you need to know about the practice of law, some of the practical limitations. And so that's going to conclude video number 3. This is your friendly, experienced lawyer, and I will see you next time. Thanks for watching.